Hello everyone, I'm Jed Rubenfeld and this is Straight Down the Middle. Well, the Supreme Court just decided a big case, the Skrmetti Case, involving a Tennessee statute that banned sex change operations and sex change medical procedures for minors. Now, I did an episode previewing the Skrmetti Case a little while back, and when I did that episode, I predicted that a majority of the court would uphold that Tennessee statute, but that there would be a strong dissent. Guess what? That's exactly what happened. What I'm going to do today is walk you through the Supreme Court opinions, let you know how the court decided, on what grounds, and why the dissenters dissented. Now, here's the funny thing about the Skrmetti case. From one point of view, it's an easy case. It's almost trivial. And the majority was clearly right. But from another point of view, it's complicated. It can get very tricky from a constitutional point of view. And it's almost difficult to follow the arguments that are necessary to decide the case. So, I'm going to run through both of those sets of arguments with you, the simple ones and the complicated ones. Now, for me, I got to tell you, I always favor more common sense perspectives and takes on constitutional law. Simple takes are usually, for me, the right ones. And it's no different here. So I'm going to tell you why I view the majority as having the better of the argument, but I'm also going to run you through the more complicated arguments that the dissent made so you can make up your own minds for yourselves. Okay, let's jump in. What did the statute say exactly? So Tennessee passed a statute that said, look, if you're over 18 and you want to do a sex change operation, have at it. We're not going to have anything to say about that. We're not going to tell you what to do. But if you're under 18, not in this state. You can't have sex change surgeries where underage girls have their breasts cut off and underage boys have something else done to them. And we're not going to let doctors give them hormones, puberty blockers either. We're not going to let them have any treatments that are designed to change them from their current sexual appearance or presentation to a gender identity that is inconsistent with the sex that they were born to, their biological sex. Okay? That's a statute. Now, what did the Supreme Court say? And what did I mean before when I said there's a simple way of looking at this and a more complicated way of looking at it? Here's what I meant. Here's a simple way of looking at it. This is a law pertaining to minors. Give me a break. Minors cannot get tattoos in most states. It's against the law. Minors cannot drink alcohol or buy alcohol in most states. It's against the law. Minors cannot buy cigarettes in most states. It's against the law. Minors cannot vote all across the country, and that's a constitutional right, voting, but minors are not allowed to do it as a matter of law, and nobody has ever thought that any of that was constitutionally problematic. All those laws are considered constitutional. Nobody doubts their constitutionality. So what's the difference? This is a law that only affects minors. Why do we sometimes prevent minors from doing stuff that adults can do? Well, we especially do it when we think that minors aren't quite old enough yet to make good decisions about matters that can be irreversible, potentially irreversible, like tattooing, or things that could potentially be harmful to them, drinking, smoking. And here, of course, there are many people who think that that's exactly what's going on with sex change procedures for minors. So, some of the way you look at this case is going to depend on your view of the science and whether that's true, that these procedures can be potentially irreversible and potentially damaging to minors. Because for a while, for some 20, 30 years, the medical establishment, the so-called experts, were saying, this is absolutely something we got to be able to do for minors. There's a condition, we call it gender dysphoria, where people suffer acute distress from having been born essentially in the wrong body. People in this condition believe and feel that they are, for example, women, even though they were born into a man's body, or that they're men, even though they were born into a woman's body. And this condition, gender dysphoria, is one of acute suffering and distress unless you treat them and give them gender affirming care. You affirm the gender they believe themselves to be, changing them away from the sex that they were biologically born into. Now, doctors were saying for years to parents, if you don't do this with your children, they're gonna suffer potentially terrible, even suicidal conditions. So doctors would say to parents, look, we understand you don't want your little girl to do that surgery, but what would you rather have? A living son or a dead daughter? What they were saying is, if you don't do this, the daughter might commit suicide. Now, if a parent hears that, they're very likely to go along. They don't want their kid to commit suicide. Problem is, as more and more science and studies were done, as more evidence came out, it turned out that a lot of what the doctors were saying was ideologically driven rather than based on scientific evidence. Turned out there was not strong evidence to show increased suicidality for kids who wanted to get the sex change operations but didn't get them. There was not even strong evidence showing that those sex change and affirming care treatments reduced depression and suffering. And on the contrary, on the other side, there was evidence that these procedures could be harmful and indeed irreversible, in some cases causing sterilization, in other cases just causing irreversible effects that could be very harmful to people later in life. So that, according to many people, is now the state of the science. So there is reason to worry that these are irreversible actions that are being taken on minors' bodies and that they're potentially harmful. Once you put that into the picture, well then, look, if you can tell minors they cannot get a tattoo, if you can tell them they can't buy cigarettes, they can't buy alcohol, how the heck are you going to tell me that it's somehow unconstitutional to tell minors that they can't get sex change operations and can't get them until they're 18? That's a simple way of looking at it. It's about minors. We prohibit minors from doing lots of stuff that we allow adults to do, including exercising constitutional rights like voting. So this case is simple, it's easy, the law is constitutional. Now, what makes the case harder? Well, here's what makes the case harder, and now things are going to start to get a little tricky. Some lawyers figured out that they could make a different kind of argument. What they said was, no. These laws, like the one that Tennessee passed, these are discriminatory. Think about it. If you said that girls could not vote until they were, let me start that over. If you said that girls couldn't vote till they're 18, but boys can vote starting at 14, everybody would say, that's unconstitutional, that's sex discriminatory. Yeah, it's only to do with minors, but you can't say that boys can vote starting at the age of 14, whereas girls can't vote until they're 18. That's sex discrimination, it's unconstitutional. So if a law is sex discriminatory, that's an exception to the rule that if it deals with minors, it's going to be fine. And these lawyers figured out they could make a claim on that basis. They said that these laws are sex discriminatory. Now, again, there's a simple response to that and a more complicated response. The simple response is, what are you talking about? And this is what the majority of the Supreme Court in the Skrmetti case said. They said, what are you talking about? The law applies identically to boys and girls. Both boys and girls cannot get sex change operations until they're 18. Okay, so it's not sex discriminatory. It applies identically and equally to both boys and girls. There's no sex discrimination. That's ridiculous. That was the simple way of looking at it, and that's what the majority said. They also made the point about it only, affecting minors, but they looked at this sex discriminatory argument and they said, no, it's not sex discriminatory. But what did the dissenters say? Okay, here's what they said. They said, hang on, we decided a kind of important case a number of decades ago. It was called Loving versus Virginia. Well, what happened in Loving versus Virginia? Well, Virginia had a statute saying folks in our state, they can't marry outside their own race. That's right, it was an anti-miscegenation statute. You can marry white people if you're white. You can marry black people if you're black, but you can't marry outside your race. Now, a lot of people would say, well, that's clearly discriminatory. But Virginia said, no, it's not discriminatory. It applies identically to everybody. white people can't marry outside their race, black people can't marry outside their race, and so forth. Actually, the law in that case was a little more complicated, but essentially that's what they were saying. It applies identically to everybody, so get over it. There's no racial discrimination at all. But the Supreme Court did not accept that argument from Virginia. The Supreme Court said, hang on a second, if you look carefully at this statute, it does discriminate on the basis of race. And it's and we can show you in what sense it does. Here's how it discriminates on the basis of race. A white man in Virginia can legally marry a white woman. Can a black man legally marry a white woman? No, he cannot. A white man can marry a white woman. A black man cannot marry a white woman. So white men are permitted to do something that black men are not. Clearly racially discriminatory, said the court back in Loving versus Virginia. And so the dissenters in Skrmetti, in an opinion written by Justice Sotomayor, they said, this is just the same. What are you talking about? If you look carefully at Tennessee's law, it's just like Loving versus Virginia. Think about it. A girl in Tennessee, a minor, 14-year-old girl, she is not permitted to take hormones to make herself look and present more masculine. But a 14-year-old boy, he can. He's permitted under the statute to take hormones to, maybe he's not going through puberty the right way. He takes these hormones, takes some testosterone to give himself some more hair on his face or something else. He's allowed to take hormones to make himself look and present more male. But a girl is not. She can't take hormones to make herself look and present more male. So, say the dissenters in Skrmetti, girls are not permitted to do something that boys are permitted to do. So there is a sex discrimination. It's just like Loving versus Virginia when you look at it that way. So it is sex discriminatory and it is unconstitutional. I told you this is getting a little complicated and tricky. So what did the majority say in response to that argument from Justice Sotomayor and the dissenters? They didn't have a very good rebuttal. They just kept repeating, but basically the statute works the same way for everybody. They didn't really have a good response to Justice Sotomayor's careful point about how the statute, when you look at it, operates differently and prevents girls from doing something that it permits boys to do. I mean, the statute also permits boys to do something that also permits girls to do something that boys can't do, but that was true in Loving versus Virginia as well. That's not a difference. So they didn't really have a great response. Now, was there a good response that they could have given? Well, honestly, I think there was. But to see that, you got to go back to Loving versus Virginia and understand something else that the court said in that case. What the court said in Loving versus Virginia famously is, hang on, this statute is a white supremacy statute. It's based on the idea that one race is superior to the other. And everybody knows it. It's based on the idea that black people are not fit to marry white people. Not the reverse. It's based on that invidious premise. It's trying to raise white people above black people. It's a white supremacy law. That's what the court said in Loving. And for that reason, it was racist and unconstitutional. Now, is that true with respect to Tennessee's statute? Does it try to raise men above women? Does it try to raise women above men? Does it try to raise one sex above the other? No, it does not. If you look at it and parse it a certain way, you can draw a comparison to Loving versus Virginia. But in Loving versus Virginia, that statute was trying to raise one race above the other. And for that reason, it was a racist statute. It wasn't just a racial classification in Loving versus Virginia. It was a racist statute premised on the idea that one race was superior to the other. And you just don't see that in Tennessee's statute. Tennessee's statute is not trying to raise boys above girls or girls above boys. So it's different from Loving versus Virginia in that very important respect. And that might be a constitutional answer to the dissenters in Skrmetti that the majority didn't really give. What is wrong with sex classifications in the law. What's wrong with them is they're sexist. That's what's been wrong with sex classifications when states used to prevent women from voting, when states used to prevent women from holding higher professions. They were sexist laws. They were trying to consign women to an inferior position in society, social, political, civil rights, whatever, economic. That's just not true of Tennessee's statute in Skrmetti. For constitutional purposes, maybe it's not enough for a law to be sex classifying, to make it unconstitutional or require heightened scrutiny. Maybe it's got to be sexist. Similarly, Loving versus Virginia, that law wasn't merely race classifying when you looked at it a certain way, it was racist. Tried to raise whites above blacks based on the idea that whites were superior to blacks. It was a white supremacy law. That's not true in Skrmetti, not a male supremacy law, not a female supremacy law. Maybe that's the simple answer that the majority should have given to the dissenters in Skrmetti. They didn't, and so that leaves the dissenters with an argument that wasn't really fully responded to by the majority. Now, the dissenters made an additional argument, and I just want to cover it for completeness. They said, hey, this law, it's not just sex discriminatory, it's also discriminatory against trans people. Trans people should be recognized as a suspect class, so this law discriminates against trans people, and that should also trigger heightened scrutiny under constitutional law, and you should strike it down on that basis too. So for completeness' sake, let me just go through that argument for you, and let me explain what's going on there. Well, in constitutional law, some classifications are considered suspect, some groups are considered suspect, and when a law discriminates against that group or treats them adversely, that triggers heightened scrutiny, can make a law very difficult to pass constitutional muster. So the minority, the dissenters, are saying that's true of trans people. They've been subject to discrimination for quite a while, and they should be viewed as a suspect class, triggering heightened scrutiny. Here's the problem with that argument, and it's, again, pretty simple. The court has recognized racial classifications, gender classifications, classifications on the basis of being a certain religion, and a couple other classifications as suspect classifications. It has pretty much stopped recognizing any new suspect classes or suspect classifications for 50 years. The court does not view disabled people as a suspect class. The court does not view old people as a suspect class. The court does not view poor people as a suspect class. All these groups have been subject to discrimination for some time, and yet the court has refused to open up the suspect class box and add new groups to it for 50 years. And as I said when I previewed Skrmetti some time ago, I said it's extremely unlikely that the court's going to suddenly say that trans people are a suspect class when people with disabilities are not, when poor people are not, when older people are not. They're not going to, the court has never even held that gay people are a suspect class for constitutional purposes. They're not going to jump trans people over that whole queue and suddenly say they're entitled to more protection than gay people, old people, disabled people, poor people. Not going to happen. And that's exactly what the majority said. They said this is not a suspect class. We've said before, we're not opening up this category of suspect classes. We almost never do that, and we're not doing it here. So that's the final argument you need to know about. Dissenters said trans people are a suspect class. Majority said no. We're not creating a new suspect class here, not when we haven't done that for all these other groups for the last 50 years. And, well, you can make up your own mind about whether that's right or wrong. Okay, I've now gone through the arguments. I'll come back to what I said at the beginning. In my view, this law only said, hey, for minors, you can't have these medical operations which are not proven to be beneficial and which are risky and which are potentially irreversible. If it's constitutional to prevent minors from getting tattoos, buying cigarettes, buying alcohol, it's got to be constitutional to prohibit minors from getting these sex change procedures and operations. That's all for me, from me for now. I'll see you next time.